Bar 2025. Civil Law. Question number 9 by Amicus Curious. Question. A was adopted by X, the owner of a local chicken and beer restaurant. For several years, X's business had been struggling. To keep the business afloat, X incurred several loans from banks in the total amount of 2.5 million Philippine pesos. One day, X figured in an accident which caused his death, leaving A as his sole heir. Upon inventory, X's estate was appraised at 1 million Philippine pesos. Subsequently, the estate of X paid the banks the entire value of the estate in the amount of 1 million Philippine pesos. But the banks still sued A for the unpaid portion of 1.5 million Philippine pesos. Will the action prosper? Decide with reasons. Suggested answer. No, the action of the banks against A will not prosper. Under Article 774 of the Civil Code of the Philippines, succession is the transmission of the rights and obligations of the decedent to the heirs, but this transmission is limited by Article 1311, which states that contracts take effect only between the parties, their assigns, and heirs, except when the rights and obligations are not transmissible by their nature or by stipulation. Jurisprudence has consistently held that heirs are not personally liable for the debts of the deceased beyond the value of the inheritance they received. In this case, A inherited an estate valued at 1 million Philippine pesos, and this amount was already used to partially settle X's debts. Since A did not receive more than 1 million Philippine pesos from the estate, she cannot be held liable for the remaining 1.5 million Philippine pesos. Therefore, the bank's action to recover the unpaid balance from A personally will not prosper. This is just a suggested answer. Use at your own risk.